Does my landlord have to provide air conditioning and heating? Air conditioning. Check your lease or tenancy agreement for mention of air conditioning. Your landlord does not have to provide air conditioning, as it's not considered a vital service. However, air conditioning may be included in your rental agreement as part of your rent or at an additional fee. If your unit came with air conditioning, your landlord has to maintain it and keep it in good working condition. For example, your apartment may have come with a window unit already installed or central air conditioning. The law states that your home must be fit for habitation, but is otherwise unclear about what this means for cooling. If you feel your place is not livable due to the hot weather, or you require air conditioning due to a health condition or disability, you should inform your landlord. If they will not make changes, you may require legal assistance. If you want to use your own window or portable air conditioning unit, you must inform your landlord. They may not permit you to install an air conditioner, or they may allow it, but state that you will need to pay more for electricity use. Heating. Your landlord cannot interfere with or withhold the supply of a vital service, which includes heat. If this occurs, contact the RHEU, Rental Housing Enforcement Unit, at 1-888-772-9277 to make a complaint as soon as possible. Get the complaint number and follow up as instructed. Your landlord must make sure the heating is working and that your unit is warm enough. Depending on where you are in Ontario, the temperature of your unit must be a minimum of 20 to 21 degrees Celsius from September 15th to June 1st of each year. What you can do if you have issues with heating. We recommend 4 steps that you can take. Step 1. Tell your landlord about the problem. If your unit is too cold because of problems like poor maintenance, poor insulation in the walls, or drafty windows, you may have a maintenance issue that the landlord is required to address. See a repairs and maintenance tenant tip sheet or video. If there is a problem with the heating in your unit, immediately tell your landlord what is wrong and ask to have the problem fixed. Take notes of when you talk to your landlord and what you both said. You should also take notes of the temperature at different times during the day and night. Speak to other tenants in your building and see if they have had similar problems. If you are experiencing similar problems, you may want to work together. If your landlord does not fix the problem as soon as possible, send a letter or email to them and keep a copy for yourself. Continue to pay your rent while your landlord works on repairing the problems. Your hydro cannot be disconnected during the winter, from November 15th to April 30th, even if there is an unpaid balance. If the utility company shuts off the supply, contact them to ask why. Make notes about who you spoke to, when, and what they said. If your landlord has told them to turn it off, ask the company to provide you a letter stating this information. Step 2. Make a complaint. If your landlord told the utility company to shut it off, contact the Rental Housing Enforcement Unit at 1-888-772-9277 and make a complaint as soon as possible. Ask for the complaint number and follow up as instructed. Step 3. Call an inspector. If your landlord does not fix the problem, you can call your local bylaw department or property standards department, your town or city hall, or your municipal office. Many cities, towns, and municipalities have inspectors who can order your landlord to fix the heating problems. If an inspector makes an order, ask for a copy of this for your records. Step 4. Apply to the Landlord and Tenant Board. You can apply to the Landlord and Tenant Board if your landlord is still refusing to fix the problem. After you apply to the Landlord and Tenant Board, they will schedule a hearing where you and your landlord can explain the problem to a board member. Before this hearing, you and your landlord may be able to mediate the problem in front of a dispute resolution officer. This is an option only when all parties are willing. At the hearing, it is up to you to convince the board member that the problem exists. It is important that you bring evidence to your hearing, for example, witnesses, photos, audio or video recordings, inspectors' reports, work orders, letters, notes, and anything that can help prove your case. For more information about your housing rights, visit www.WRCLS.ca. You can also contact Waterloo Region Community Legal Services at www.wrcls.ca/web-contact or call us at 519-743-0254. Check out our YouTube channel for more videos.